But the goal here is not this just to record as much as I like talking to Laurent, is also for you to get your questions answered. We have a couple good ones. If I could jump in here, Laurent. One is somebody said trust avoids probate and associated expenses. However, what expenses should be accepted? I'm sorry. I don't know why I'm not reading right. A trust avoids probate and associated expenses. However, what expenses should be expected for the administration of the trust assets, i.e., the trustee annual reports, trustee fees, and things like that. So there's costs for the administration of the trust. What are those in compared to, say, a probate?
Much less is at the end of the day what you want to hear and what it should be. A probate is usually, again, 4 to 8% is roughly what you're going to be paying of the assets to both the attorney and the executor. When it comes to trust admin, you're looking at usually 1 to 2% of the assets. Now, the percentage obviously varies because it's much lower when you bring me a $30 million estate. It's not going to be as expensive as, you think about 2% of that could be pretty insane. So it just depends on what we're talking about. If it's like a house or something, it's obviously more expensive than if it's 10 houses, right? So
those fees are negotiable.
Hopefully that answered your question.
I imagine these fees are negotiable.
Completely.
Yeah, and it
could also be hourly, by the way. Just so you know, there's some people that do it hourly.
Right. If it's hourly, there's less work involved. For example, in a trust, you're not typically going to court, whereas a probate, everything's going to court, or at least there's court appearances and fees and filings and such. So it cuts down to some of the administrative costs. But so the answer is it's negotiable. Look, wealth management companies charge me 1% to administer funds when you invest with them, stocks and bonds and things like that. So 1% to 2% sounds like a fairly reasonable number, but it depends on the assets and depends on the administrator. And so in your practice as an attorney, you set up trust. Do you also administer trust? Is that part of your practice, or is that something that you refer out?
No, I do that. I do the administration, whether it's probate, whether it's trust administration. I set up trusts. I litigate trusts when we need to go to court over. But not all trusts are good, right? There's a lot of people that go on LegalZoom and pull up a trust, and they think they're all fine until there's a missing provision, and then I got to go to court and fix it, or some beneficiary is squawking over it, and we need to address it. That could also be another a year or two in court just handling that. So yeah, I do all the above when it comes to trust and estate, the types of work that you could do in this field.
Everything is good until it's not good. That's when you have a problem. So let's talk about that for a second. Right. I think we probably disagree on this a little bit, respectfully. Again, from a business perspective, you from an attorney perspective, and I guess it depends on what you see more of, right? I tend to see more, probably my business skews more middle income, and I would imagine trusts and estate planning tends to skew more upper income because you have more assets to be worried about. But to me, it seems that you're better off with a bad trust than no trust about 90% of the time. At least get something. Now, clearly, 10% of the time there's a mess, and I see that litigated in court, both attorney prepared and LegalZoom prepared trusts. But it seems to me better for most people, if you have a simple situation, at least have something than not do anything. True or not true?
I would say, yeah, but there's a risk of it being way more expensive, right? So you're rolling the dice at the end of the day. And yes, I'm coming from an attorney perspective that has been to court, been to trial over literal changes in trust, whether sometimes they're handwritten, sometimes they're done on the deathbed, sometimes they are done under some sort of fraudulent circumstances. And what we need to do now is go and depose everybody, and you have a bunch of lawyer fees, and at the end of the day, you're reducing the inheritance for the people that are getting the money. So I don't know. If it was done right, you wouldn't have had to gone through that. So that's the way I see it, and I think that it's an important point, and you might not be seeing it as much because, I mean, you're not part of those cases, but I do see them, and they're very prevalent.
Well, I'm not looking for them. I mean, to be honest, right? I'm looking for the probate cases with litigation. I'm not looking for the trust. The trust cases get litigated, but I don't see. I'm not searching them out as much from a data point of view. So that's why I don't see that. I know my perspective is a little skewed, but I feel like there's no excuse not to get started. And I always feel like if you have a bad trust, get it done, then take it to an attorney and rewrite it. But at least now you have your names out, you have the data going, but you got to get into action and get something done to protect yourself. I think at the end of the day, we both agree on that.
Okay, if you enjoyed the video, your next step is to sign up for the webinar by clicking the link above. If you have any questions or concerns, go ahead and comment below. Be happy to address them. See you soon.